was this commitment to the law, to the idea of accountability. But the second issue was, here was the ICC, which could potentially have jurisdiction over the US without our consent. And the US has long taken the view that if its nationals are going to be subject to international jurisdiction, it should be through an arrangement whereby we give our consent. And although the ICC is not a court of universal jurisdiction, states have to consent or be referred by the Security Council. But if a territorial state consents, then the conduct of other states' nationals on their territory could be subject to the court's jurisdiction, even if that state hasn't given its consent. So how do you reconcile these two ideas, this idea of a commitment, I think a genuine commitment to accountability over time, and then this particular issue with the ICC? So I'll turn it over to Bill on that.
Thanks, I feel like I have to take it now. I think that's a great setup, actually, and that's, throughout every negotiation I was in and across those administrations, I haven't been in the Trump administration, but the same animating factors are at play. But you've got, ending impunity on the one side, accountability, and then you've got a problematic jurisdictional regime from a U.S. perspective on the other hand. And if I could break that one down a little bit, the problematic jurisdictional regime, I see it as kind of two components: a structural problem associated with the reduced role of the Security Council, if you will. If you think of the Security Council having had a corner on the market on coercive physical authority, only under international legal regime, only the Security Council could authorize forcible anything, detention of a person or armed conflict or whatever. Well, with the International Criminal Court, you now have a judicial arm that can order someone into confinement. A person, not a state, but still there's a structural change there that very few proponents are really worried about because they want to end impunity, understandably. The second component of the jurisdictional criticism was the fear of politically motivated prosecutions. And I remember it very well because I was the guy drafting the PowerPoint slides for the Joint Chiefs of Staff. What is the concern? Politically motivated prosecutions. What are the upsides? Ending impunity and assisting in that. And that was the dynamic that was at play. And I think if you go to either extreme, you could argue the court does more harm than good because it theoretically takes jurisdiction over parties haven't submitted themselves to that jurisdiction, and that itself harms the rule of law. Then you could try to undermine the court. Or you could say, hey, this might not be ideal, but come on, this, as we've heard all the positive things, this helps bring people to justice. And that in play has put, I believe, the United States position pretty consistently in the middle of wait and see how the court behaves and see how it performs its functions. I think some would argue that after the Clinton administration, the beginning of the Bush administration, there was certainly a greater emphasis on the negative side of what the harm the court could do, but it never really went forcefully against the court. And by the end of the Bush administration, it was again back in that middle ground, which is where I think we've largely been since.
Just to add a couple points, if I could, I think the system of complementarity that gives primacy to national authorities, with the court only stepping in as a last resort, is a protection that the U.S. worked hard to include. I think there's a lot of value in that because in the end, it's national justice systems that need to be strengthened to be able to genuinely, try to prevent and seek accountability for these crimes. But our European allies in the end were satisfied that that was sufficient to protect their concerns, and the U.S. was, historically has been more skeptical. So it's just important. There are plenty of strong democracies, our closest allies, who have felt that arrangement was sufficient. And I would say that the first part of the Bush administration, there was a lot of hostility toward the court through John Bolton, who went out and said, we're going to unsign the treaty, we're going to negotiate these Article 98 agreements, and really try to undercut the court in very, very significant ways. Then that changed during the second Bush administration when the president himself realized that the Darfur situation was a situation where the court could be helpful and was probably the only useful prospect for justice. The Obama administration, in which I served, I think decided to engage much more intensively with the court because it felt it was having some valuable effects, both the general effects we've talked about and concretely in certain cases. And the Obama administration spoke up in favor of each of the investigations and situations and convictions by the court. It provided tangible assistance by helping to turn over 2 indictees, including Dominic Ongwen of the Lord's Resistance Army, who's on trial now. It expanded the War Crimes Rewards Program to include the ability to offer up to $5 million for the information leading to the arrest and transfer of individuals wanted by the court. It attended the Assembly of States Parties. It attended the negotiations, the Kampala negotiations over the crime of aggression. So it, I think, engaged and supported the court in a much more systematic way. Now in the Trump administration, and I guess we'll get to that, we have John Bolton again rising up in even a more extreme form than he took in the first Bush administration.
We're going to dig a little deeper in the current status with the Bolton speech of September 10th in a moment. But Alex and Kip, do you want to add to the?
I think I would just add to what Bill said about the anxiety about politically motivated prosecutions by the International Criminal Court. That, of course, is not that there's a deeper kind of history and resonance there about there's a deep strand of anxiety in U.S. political thought, anxiety about international institutions and international commitments, and going to your point earlier about giving up sovereignty, that is not shared by other allies, for example, the Europeans. European political thinking is much more attuned towards international institutions, international solutions than the United States is, and there are good reasons and bad reasons for that. But it's not this thing of there's a sort of deep history to that kind of anxiety about the international criminal court.
The nationalism debate between Macron and Trump right now.
Right. You see it flaring up, and the jurisdictional point that's really a legal point, and it's solved. The jurisdictional thing would be solved if the U.S. joined, right? I mean, that's only an issue if the U.S. is out.
There were many other ways to solve it too, Alex.
No, but I mean, that's a legal objection when you're on the outside. But if you're on the inside, that's no longer an issue. So there's the question then becomes, why aren't we on the inside? And I think it goes to what you said about the concern about politically motivated prosecutions, which has this history.
I think Alex is exactly right about kind of there's a, for lack of a better word, this emotional response about kind of distrust of international institutions, kind of fear of the rule of law being used against the United States in what we deem an unfair or unjust way. And obviously the kind of nationalism, populism is kind of certainly taking that emotional response and running with it. But I always, and I don't think we'll get to the answer here, but I always, and Bill's point about kind of wait and see, I've always wondered what is the metrics of waiting and seeing? When are we actually going to say, oh, this is actually a professional institution? It's actually abiding by the rule of law. It's actually not doing political prosecutions. No one's really talked about that. And for instance, right now, if you do look at the track record, a lot of the judges have thrown out a lot of cases for lack of evidence. And so I would always be curious about that kind of actual legal analysis, the clinical analysis of the court's performance. That what Clinton said when they signed the statute, that we'll just wait and see how the court goes. How do we actually do that?
Right. Okay. Let me again, for those of you who are less informed than some of the others in the room, the word complementarity has been mentioned by several members of this panel. And the politics, the worry in Rome that creating this court would do harm to the sovereignty of all nations having to give up their sovereign powers. So I think it's worth keeping in mind that the Rome Statute, which is also a multilateral treaty, for the first time, codified existing international criminal law, which was diffuse, and it came from treaties, it came from legislation, domestic, it came from cases, court cases. So the Rome Statute is this incredible codification of international criminal law. That's the very first important thing that I think that the ICC did. The second thing was, in order to get 100 and now 24 nations to agree to subject themselves, they had complementarity was the key, because complementarity, as Jane said, gives the state, the nation individually, the first responsibility to enforce the Rome Statute laws in, say, let's say, the United States, or in China, or the Soviet Union. And if that state either doesn't have a mature, non-corrupt justice system and does not enforce, that's the only time the ICC can come in and take jurisdiction of the state's parties. Complementarity was a genius idea. Some people think that it was a concession to the powers because even though the U.S. hasn't signed up, the U.S. argued for complementarity, as did many other countries, to give the country involved the first crack at doing justice. So complementarity is in a way what is the core of the agreement in the Rome Statute. And the other thing that the Rome Statute did is it created individual responsibility, not national responsibility for committing these crimes. So all the crimes, genocide, war crimes, crimes against humanity, the court looks not to the country but to the individual who caused it, whether it be a leader, whether it be whoever it is. And the people, it isn't countries that after trials are serving 50 years or 30 years in prison. It's the individuals, the dictator, the people who cause these crimes to happen. Okay, with that, let me ask, what is it that the U.S., since Nuremberg trials, has been looked to as the champion of human rights, the champion of due process, the champion of making sure that crimes are punished and sanctioned after a fair trial? The U.S. was in Rome. Bill was in Rome. He was there. He listened to these discussions. He knows from 1998 to now, the U.S. has made significant contributions, even though we're not a party to the court. So very briefly, list 2 or 3 things that the U.S. has contributed to the Rome Statute and the way the court operates before we get to the current Bolton situation.
Contributed Alex.
No, but that's actually a good point. I mean, there has been American practitioners there at senior levels like Alex, and then not just in the prosecution, but the judiciary, not judges, of course, but within the judicial staff and defense attorneys, and certainly that exchange of expertise and kind of bringing the American rule of law system to bear in actual practical form. This is a real contribution. And again, I think we've touched on some of it with the elements of crimes that Bill worked on, which is a big contribution to the consistent application of the law. Those are just a couple that come to mind for me.
Okay.
Yeah, I mean, Jane mentioned a bunch of them already, that particularly in the Obama administration. But the U.S. helped shape some of the provisions of the International Criminal Court, complementarity, some checks on the independence of the prosecutor. So if the prosecutor wants to begin a case on his or her own authority, he or she has to get authority from the pretrial chamber. So those were things I think that were in part in response to U.S. concerns, even though it ultimately did not win over the U.S. The U.S. has also twice allowed for referrals from the Security Council to the International Criminal Court. Jane mentioned the first one, which was Sudan, and the second one in 2011 was Libya. So there have been ways that the U.S. has both shaped the law and supported the work of the court.
Right. Good. Anyone else want to weigh in?
Well, I think Jane might have mentioned, but evidence. The U.S. has clearly provided evidence that can be used in trials. In an ironic twist of fate, I was at the first U.S. company, PAE, that actually had employees that had evidence, and talked to the State Department, went to The Hague, delivered boxes of evidence because we were in a camp in Sudan when crimes were alleged to have occurred. But the U.S. is very much supportive of the ending impunity piece, and has been. And in that regard, providing evidence for prosecutions that are appropriate have always been part of
Okay,
our
on the other hand, because at the court we were sometimes frustrated because we couldn't get evidence. There is a statute which prohibits, restricts cooperation with the court, prohibits governmental cooperation with the court, and prohibits U.S. Any ICC investigation on U.S. soil.
Why do you gotta be
So
so negative?
because I'll tell you two frustrations, right? Sorry, I know you wanted to be positive, but we're going into the frustrations.
We want to be truthful.
Okay, two of them. So the first thing is, one of the big exciting developments in investigations now is social media and internet, and mining, open source. That's what I'm looking for. Mining that for evidence, and those roads often lead to Google, Facebook, all of those companies. Well, the International Criminal Court cannot get information from those companies because the ordinary way to do that is a foreign government can. They file an MLAT that goes through the Justice Department, and the Justice Department then files a subpoena to get the information. That's the court, the ICC cannot do that. So that's all that information is blocked. Trying to get email information or social media information from companies, even though I think those companies would be happy to cooperate, but they're unable to really. And then the second thing is when we had I mentioned that the U.S. Voted for the Libya referral in 2011. Well, I was there. I was at the court, and there were two UN representatives from Libya who had defected very early on, and we wanted to interview them. They're great witnesses. They're part of the regime. They defected. Wonderful. They're in New York. We'll come to No, can't come to New York. I'm barred by U.S. law to interview them in New York. So then we said, okay, we'll interview. We thought we were clever. We'll interview them in a consulate, some country and that's not U.S. territory. And the State Department said, no, that's still under the law. That's still so. For witnesses who were located in the U.S., we had to fly them out. We had to move them to Canada or fly them overseas. So.
Yeah, so there are a lot of restrictions. I think it's good to be realistic about that, and just to underscore a couple of the positives, as I mentioned earlier, helping to get several suspects before the court, but also I think working in a complementary fashion with the court. So the U.S. has done a lot of work and supported the hybrid court in the Central African Republic, which is something that both the ICC, Office of the Prosecutor, and the U.S. government sees as a very important complement to the work of the court. The U.S. has worked a lot on the peace negotiations in Colombia that included some innovative justice provisions still to be fully implemented, and it's a work in progress. But that's an area where I think both the ICC and the U.S. were interested in making sure that justice had a seat at the table and had some real inclusion in the peace agreement. And I could give other examples of hybrids and forms of domestic accountability that I think are where the U.S. and the ICC are working in a complementary fashion.
So I think if I've heard all of you, I have. The reason I asked the question is what has the U.S. contributed to the way the court operates since Rome? The U.S. track record before Rome, from Nuremberg forward. The U.S. has been really the standard, the gold standard in international criminal justice. But that has changed. That has changed. And we're going to look at some of the reasons mentioned the ABA's ICC project. We created it. Started to create it in 2011, and it came into full existence in 2012, 6 years ago. We have a board of advisors, and Bill and Alex are members of the 17-member eminent multinational board of advisors, which has on it the very men and women who created the court. Sharif Bassiani was chair of the drafting committee of the Rome Statute. He's been on our board. Philippe Kirsch was the first president of the International Criminal Court. He was in Rome. Sandra Day O'Connor, Patricia Wall of the DC Circuit Court of Appeals, the Lietzau from the Department of Defense, so many others, American and overseas. And what the reason the project was created in 2012, the Aba Icc Project, is that we came to realize that under the Rome Statute, there are 18 judges, 32 prosecutors, and then there's a registrar that operates the court. What we came to realize is that the judges who rotate, they have 6-year terms. The first and second batches of judges of those 18, half of them were appointed to the court, selected for the court by the Assembly of States Parties because of their distinct reputations in their own nations. They were career diplomats. They were the most respected people in those nations. But half of them, 9 of them, give or take, weren't judges. They had little relationship to courts. And so there was this gap that we had to help fill. And so I would add to the answers that you all gave, the fact that the United States judges, retired judges, prosecutors, retired prosecutors, through the Aba Icc Project, have been helping to train personnel at the court. And when Kip and I had our first and second and third and fourth meetings with the president of the ICC and the prosecutor of the ICC offering our help, U.S. help, there was excitement, there was enthusiasm, there was warm reception because they knew they needed the help. And the president of the ICC, I remember vividly, after one long meeting at The Hague, the President Song said, Michael, you have to understand, of the 9 or so judges on the court who need some training are very proud. They don't want to admit that they need training. So can we not use the word training? And I said, we can call it whatever you want to call it. And I think it was Kip who said, how about sharing best practices, as a substitute for training? But the judge said something that I thought was both humorous but also true. He said, Michael, those 9 judges, some of them think that they are legends in their own time. And I said, well, we have a variation of that phrase, Mr. President, that some people on the court and off the court think they are legends in their own minds. And he said, oh, I like that better. I like that better. So the fact remains that in one way or another, the U.S., the legal profession, the judiciary of our country has done a lot to help this court, nurture this court. And now we come to the September 10th speech in which John Bolton presented the position of the Trump administration towards the court. And maybe someone on the court, on the panel, can very briefly reduce to an essence, what is it that Bolton said? And what is the Trump administration's position as interpreted through the Bolton speech? And then we'll go after that to what we're going to do about it.
Alex and Jane wrote great pieces in Just Security on this, so I think.
Well, let's start with the two of them.
So, I mean, of course, as Jane said, John Bolton led the opposition to the court back in 2002. So this is John Bolton's, the sequel. And what spurred the speech was that a year ago, in November of last year, almost a year ago to the day.
Yeah.
The prosecutor at the International Criminal Court filed a request to the pretrial chamber to authorize an investigation in Afghanistan, including of U.S. personnel, both Defense Department personnel and CIA personnel. In Afghanistan, Poland, Romania, and Lithuania. Poland, Romania, and Lithuania are the black sites. The U.S. personnel looked at solely for detention, mistreatment of detainees, including torture. That has not been ruled on yet by the pretrial chamber, but it's anticipated that it will be ruled on any day, and I think it's been anticipated that the pretrial chamber will approve the investigation. So that was the spark for Bolton's speech, and he said, look, if that happens, then we will oppose it in every possible way. We will encourage members of the court to cut off funding. Our goal is to shut down the court. We will enter into Article 98 agreements with nations which are agreements whereby nations agree not to turn over U.S. personnel if they're charged by the court, because countries that are members of the court have a legal obligation to turn over anybody who's charged. And then it went so far as to, and many people thought this was kind of bluster, but to say that we would we'd freeze assets, prohibit travel, and even criminally prosecute any members of the court, judges, prosecutors, investigators, and so forth. So it was an extremely aggressive, virulent speech by John Bolton, and the question is, how is it a speech, or how? Or I mean, it is obviously a speech, but is it going to be more than a speech? How much is he going to press to implement that? Some of the things are there's no way to implement, but there's some things he could do. I mean, I think if he really committed to it, I think there are actual things that could be done.
Jane, do you want to?
Yeah, no, that was a very good summary and analysis. And I personally think, I think probably most of us think that the Bolton approach was counterproductive. I mean, if what you were trying to do was protect U.S. interests in relationship to the Afghanistan situation, I think a calmer, less shrill, less extreme approach would be more likely to be effective in working with the challenging issues ahead. So I think on just that very narrow ground, it was counterproductive, and we can talk more about that. I also think it was counterproductive in terms of undercutting the longer-term U.S. interests in justice and accountability, because it puts us against this institution that has had some positive effects that we historically have supported, and our allies support. So it's counterproductive in that respect as well. And I think hurling a wrecking ball at the court and trying to undercut it also undercuts its work at complementarity, its work to strengthen domestic accountability, which is something that the U.S. believes in, that I would think Bolton believes in. So I think it's deeply counterproductive in all those ways, and I hope, as Alex suggested, that it's more bluster than reality. But time will tell. Bill may have some thoughts on that.
Yeah, I'm not, now, to be fair, I don't know John Bolton, and I haven't talked to him, and he didn't consult with me on the speech. But I'm not sure that it is as much bluster as you say. And to be fair, I think in some earlier comments, we mentioned, Bolton was here early in the Bush administration, Bolton's here now. Oh, coincidence, look how we've tended toward what I viewed as I don't know which hand I had the negative jurisdictional concerns on. But I think in some ways he's personified the court as not just a potentially bad idea, it's a bad idea, and we should try to undermine it because it does more harm to the rule of law than good. That, at least his public remarks have suggested that he sits there. I think my point earlier would have been that's a coherent and potentially consistent policy position to take. You may not agree with it, but it is one. You can take the opposite position too. We've tended to be in the middle across administrations. To his defense of having to give that speech now in 2018, when we look at what happened this year, we've got the two events that tend us toward realizing that those concerns might be bigger concerns than some have said. I wrote a blog on complementarity that suggested that the Afghanistan investigation has taught us that complementarity isn't as useful to the United States as we might have. I think it was in Just Security too, but I'm not even sure. But if you look at what has happened here, 20 years ago we're saying, oh, politically motivated prosecutions. And I have to admit, as we're writing those on the slide, I'm not actually thinking that the ICC will have a politically motivated prosecution against the United States. But when you look at the reality of US detention practice in Afghanistan, everyone's familiar that detainees in the US haven't been a popular combination in the last decade. Abu Ghraib makes that clear. But when you look at the language, the kind of threshold gravity language associated with the ICC, look through the preamble, a crime against humanity, widespread and systematic attack against the civilian population, for war crimes, common plan or policy, for a large scale system of attacks. It is very hard for anyone knowledgeable of US detention practice to see how in the world we possibly come close to an actual ICC investigation for those things. And while, yes, maybe, I forget what word you used, but the more aggressive recent remarks might be counterproductive, arguably. On the other hand, the softer approach is what we have been using since at least 2013. My last official act in the Obama administration was to fly to The Hague, talk to the prosecutors, and say, hey, you're about to say we have reason to believe the US has committed war crimes, and you haven't shown us anything that we can possibly identify as a war crime. And for the ICC prosecutor to say we have reason to believe, I mean, imagine that in a US court. You'd never have a police officer or a prosecutor prior to the indictment, prior to even having an official investigation, in a preliminary inquiry to a maybe official investigation, to maybe an indictment, saying, I've concluded there's reason to believe that a war crime's been committed. How do you defend against that? So my point is, the circumstances have put the United States in a difficult position right now, where that idea of a politically motivated prosecution becomes more real. Unfortunately, I'll throw one other thing out there. I mentioned the structural concerns as well. Well, aggression just became a crime that's now implementable by the ICC. That kind of goes straight to the heart of what's the Security Council's role in international government. So you've got two things happening in 2018 that, whether or not it happens to be a National Security Advisor Bolton, I think whoever was in office was going to necessarily have a more contentious set of remarks toward the ICC.
Okay.
Just a couple points. I think trying to predict the Trump administration is a really stupid thing for me to try to do. But I would, and I agree with what Alex said and what Bill said about it maybe be more than bluster. However, to me, it very much came across as just a threat as it relates to Americans, because, and using the Wrecking Ball logo as Jane talked about, you would hope, and I think that they probably do exist, reasonable voices that would say, are we really going to take a wrecking ball to this court when its first cases could be in Afghanistan against Taliban and Islamic State individuals for atrocity crimes? Now, that doesn't mean we'll maybe actively be supporting it, but do we really want to destroy this institution doing that type of work? And then additionally, in Venezuela, the court is looking to do investigations in Venezuela, something that I think the administration would very much be supportive of, maybe not publicly, but internally. And then also, as it relates to Myanmar, the court has some limited jurisdiction there. So I think that speech was very much directed at the kind of the threat to Americans. And yes, there was a lot of very clear threats to the institution, U.S. threats to the institution of the ICC. But just one last point, I'll try to be as quick as possible. I think Bill's point, and actually I trust a colleague of mine used this kind of analogy. The United States is having this ability conversation, about our ability of, because of the Rome statute says that the court can only get in if the domestic jurisdiction is genuinely unwilling or unable. And the United States seems to be having an ability where we have a great judiciary. Don't question our judiciary. We're doing the thing. The ICC is very much having a political will discussion. They may see that there's a detention practice that is great. They may see these things, but they're saying, yeah, but we know this went higher. We know that this policy, legal memos, John Yoo memos, this went higher than just what happened here. They're having a political will discussion. It's kind of that cross-purpose discussion, which is, I think, at the tension right now between the U.S. and ICC.
Can I jump in?
Sure.
So I agree with Bill that the landscape changed in the last year because of the Afghanistan investigation. Also in play is a potential investigation in Palestine, Israel, and then the aggression amendment. I also agree. I want to be clear that I also agree that that the concern about politically motivated prosecutions is I think a legitimate concern. I don't dismiss that. It's a question of how you manage that. But the reality is that the cases of war crimes, crimes against humanity, genocide, these are worldwide cases that get worldwide attention, and there's enormous political discussion and political pressure to have accountability, against the United States, against Russia, and the court feels a lot of pressure. That is a reality, and the question is, how do you manage that? The one thing I would differ though is on the U.S. detention practices. There is an argument about whether it meets the gravity threshold, because the numbers are actually quite low. Even the court says it's under 100, and it's a relatively short period of time. However, the problem for the U.S. is that there's two problems. First of all, it's torture. It's torture, and it's very hard to get around. It's very hard to get around torture in terms of gravity. And secondly, at least on this may be not true on the Defense Department side, which is where you focus mostly, but it's certainly true on the CIA side. It was pursuant to policy at a very high level, and the war crimes provision says widespread or pursuant to policy. So if you're at the International Criminal Court and you're just trying to apply the law, and I'll tell you, they're not that excited to do this case. They have not rushed into it. It took them 10 years even to ask to start an investigation. It's very hard to find a legal way not to do it. All the legal pressures push you to, forget about the politics. So I don't think the Afghanistan investigation is a politically motivated prosecution. It is a straightforward application of the law. Finally, having said that, I think it's a mistake for the ICC to pursue it, and they should find using discretion, not some twisting of the law, but using discretion, should find a way to focus on other things and not focus on that case. And I can say more about that.
Well,
later.
let me make a comment, because the Assembly of States Parties, the 123 nations, 124 nations, meets twice a year at the UN, typically in the U.S., and in The Hague. And at the last meeting that I attended some 6 months ago or less in New York, one of the nice things about that meeting is that people come from all over the world, all those nations, including the U.S. The U.S. has great presence there. The U.S. officially makes statements to the Assembly of States Parties, and there are informal conversations that go on, side events that go on, that they're talking about various issues. But there's also time to have a cup of coffee or a beer with friends. And Kip and I had a meeting with Fatou Bensouda. We had over a cup of coffee, which is typical because we've developed a friendship, both professional and personal, with members of the court, including the prosecutor. And it had just been announced before that meeting that the prosecutor had asked the judges of the ICC to authorize her to investigation of anyone who committed atrocity crimes in Afghanistan, whether it's the U.S., Great Britain, any country. So it isn't just targeted at the U.S. And as we're talking, I said, Fatu, you know that there's going to be an explosion in the United States if the court authorizes this investigation. You know that. I said, why are you taking this risk? What is it that's, and essentially, because of what Alex was just saying, torture is the one crime that all nations have agreed is despicable, unacceptable under any circumstances. There shall be no torture. And Fatu said, Mike, I'm doing my job. I'm the prosecutor. I have to implement for all nations, not just the African nations, but anyone who has committed these crimes, I have an obligation and duty to go forward. And the fact that there's an investigation doesn't mean that there's going to be an indictment. But if we give any power a pass, then that's going to harm the whole concept of international criminal justice, because even now, the African nations are saying, you're picking on us, even though most of those referrals in Africa have come from the countries themselves. People don't know that. They think that it's the prosecutor who's going, and she's from Africa herself. The only case that was not self-referred by an African nation was Kenya. And there was good reason for the prosecutor to open an investigation, an indictment, in a trial that was frustrated because the Kenyan leaders found ways to undermine the start of that trial. So,
Can I just make since we're on Afghanistan, I don't know if we'll come back to it.
No, we're on Afghanistan.
Yeah,
We're
so
still on Afghanistan.
We're still on Afghanistan. I just wanted.
Because we need to know how the U.S.
Right.
should respond. That's the next question.
Right. Oh, okay. Well, I just had a couple of thoughts on that. I mean, one, and Alex has written about this too, I think the U.S. should sort of take a deep breath, right? Because there's time. I mean, it will take time for this thing to unfold. And because the U.S. is not able to cooperate by statute, it's
Nor does it want to.
Nor does it want to. It's going to be hard for the ICC to make headway on this, and so there's time to sort of take a deep breath and think about what the best approach is. And on that score, I would sort of stress two things. One, I think the U.S. should do more transparently to address what it has done on accountability and complementarity, and what more it could do. And here, Bill may be able to talk a little bit about on the DoD side. I think there's been obviously more done on the DoD side than on the CIA side, where it's a much thinner record. But still, there hasn't been much transparency, much, sort of, and I think first and foremost to the American people, we ought to have a fuller account on these issues. A second thing the U.S. could do is be much more firm and categorical about our opposition to torture. I mean, the Obama administration was very clear on this through its executive orders, through its statements to the Committee Against Torture, that torture is forbidden under all circumstances, through statutory changes in the law to sort of solidify a course correction after the problems in the aftermath of 9/11. Secretary Mattis has made these strong statements, but the administration as a whole has, and the president has said things that point in the other direction. So I think that is something the U.S. really needs to do, is affirm categorically our opposition to torture. And we also need to keep in mind the larger interests that we have in the court and its work, and the other crimes, as Kip mentioned, that the court is addressing, where we really have a stake in the court being able to continue its work effectively. And to say the court is dead to us, as John Bolton did, and in fact to say we want to make sure it's really dead, and take steps to make it, undercut it, I think is really, really not in our interest.
I'd like to pick up on that. I think that, of course, demonstrating U.S. accountability, demonstrating U.S. resolve for human rights is always positive, and you can never go wrong with it. I think it would be unfair to suggest that the lack of that is what took us to where we are today. Similarly, I don't think it would be fair, as Mike kind of pointed out, to not recognize that the prosecutor is between a rock and a hard place. It would be odd to say we think we should launch an investigation into everything that took place in this region of the world for a period of time, excluding the United States. That would be, there's a political motivation, if you will, to not do that or whatever. And I agree, when I talk about politically motivated prosecutions, I don't think anyone's saying, oh, let's bring the US down, because I don't think they've even identified any human being they could actually prosecute. But the point is, they've got a situation where it's, in my opinion, a little bit absurd to investigate US practices in Afghanistan, knowing all the facts, and I have a fairly good feel for the facts. And I can't speak as widely to CIA practices, nor should I be able to, nor do I want to be able to. But even then, we're talking very small numbers. You know, watch the YouTube videos of the interrogators and everything else. This is hardly the thing that, even on the CIA side, in its worst state, it's not what the ICC was put together to put a stop to. All that to say, we've done quite a bit. There's at least 10 investigations on US detention practices that have largely been published. In fact, the ICC uses them in their claims that they have reason to believe certain things happen, because they make a logical leap where they say, here in this year, a policy was put in place to not do A, B, and C. And there's a presumption then that prior to then, there must have been a policy where you could do A, B, and C. That's a problem with the syllogism, because it's almost like, well, when you investigate yourselves and you exercise complementarity and you are very open, you're actually putting evidence out there that we can use to justify the prosecution, though it won't hold up in the long run. But I guess my point is, the prosecutor is in an awkward position. They've painted themselves into a corner because of their own internal policies on being open with preliminary inquiries and where they stand. So they can't say, well, we'll do it differently for the United States. And by taking entire situations, well, we can't do it differently for the United States. I disagree with that. But I guess my point would be, that doesn't change a National Security Advisor Bolton perspective that the very existence of a proprio motu prosecutor is the problem. And I think it was. I think in hindsight, it's a lesson learned by the world community. You know, as the United States is saying, crassly put, let the Security Council have its more significant role in referring prosecutions. No, that itself is political motivation. We want a independent prosecutor who is not politically motivated at all, is purely just interests of justice. Well, the counter to that was you can't. A proprio motu prosecutor can't avoid the politics of decisions of where to go forward. And now the prosecutor's in a very difficult position because they have to. In a way, it would have been nicer to have a referral mechanism that just pushed it into the prosecutor's hand. It wasn't a prosecutor decision. And then she can clearly say, I'm doing my job. And it would be much easier. So we're in a very, I guess my point is, there's no easy answer, and you can't just point at people on the court and say, you made a mistake, and you can't really point to the US and say, you should have a different attitude. The circumstances have put us where we are, and now we have to grapple with a very difficult problem.
Kind of feeding off of everything that's said before, I think obviously I was not part of the conversations, you know, from what I've been talking to, kind of, let's say, the two sides, both sides feel like the other side is not being fully transparent. I'm not going to question whether the truth of that matter, but I bring that point up simply about if we're on the question of what the U.S. should do, and I can already feel Alex will start maybe rolling his eyes when I say this, and I'm ready, and Bill may have other physical reactions. But honestly, in terms of, and I think this goes off Jane's point, if the United States was more transparent, particularly on the CIA side, and actually talked about in depth what they've done and what they haven't done, it would really move the conversation forward. Now, if we're taking out all the kind of the stigmatization of war crimes, because that has a double-edged sword. The stigma of war crimes as a prosecutor staying in a prosecutor prison is a great thing. It's a deterrent value. It helps eliminate people who are kind of bad actors, the stigma of the war crime label. The double-edged sword of that is that it's actually, I think in some ways, preventing the United States from being more transparent. Because if you talk to certain circles and say the Heritage Foundation, how dare you call us war criminals on par with Nazis and others who have been, but war crime can be not giving a fair trial. So the stigma has this kind of double-edged sword. But if we put that stigma away, what is the most clear policy decision to make the whole Afghanistan situation go away? The United States to do full accountability domestically. That has the most clear outcome, and it would be the fastest way to get to that outcome.
I'm rolling my eyes.
He's rolling his eyes. But if we're talking about pure policy and kind of geopolitics, and again, yes, definitely I adhere to the good luck internally in the United States, but my point just being is this policy decision, that would have the most clear outcome. Now, the opposite, let me just quickly say in the opposite, kind of the John Bolton routine, and possible where that comes. Let's just say that there was arrest warrants put out for American. You now have 123 state parties where they have a legal obligation to turn over, and lots of these are allies. And think about our already strained relationships, particularly the transatlantic strained relationship. Think about that added pressure on them, which is something that the Europeans and the United States have really always seen at odds about when it comes to the ICC. So that kind of added pressure of arrest warrants, of putting our allies in weird positions, of kind of being on, the United States being in a very public way attacking a permanent international criminal court for atrocity crimes, that is the worst outcome of all there. So yes, maybe there's something in between, and Alex is brilliant enough to figure out that in between, and Jane and others, but my point being is that there, those two outcomes of what we're kind of looking at right now.
Okay, Alex, and then I want to open the floor to some questions.
So I just would say this, and we've talked a lot about complementarity and how complementarity plays in here. And Kip has just made the argument that complementarity could be the way out of this problem. The problem, the problem is that the law on complementarity at the ICC has developed in a very rigid, narrow way, and that legally ties the hands of the court. Mm-hmm. So the way the law has developed is that domestic accountability. It's not a question of like, oh, you vaguely have been held people accountable, you've had investigations, or you've prosecuted a few people. No, it's much more rigid and demanding than that. It is that the domestic authorities have to prosecute the same people for substantially the same conduct. So until senior people are prosecuted for detainee abuse, whether on the DOD side or more likely on the CIA side, complementarity will not bar the investigation. Now, I think in retrospect that's probably too rigid a test. And it's unfortunate, but that is the legal reality. And the idea that we are going to have prosecutions of people for detainee abuse at this stage is inconceivable. Remember, it wasn't John Bolton who blocked those, it was President Obama who said no to that. And there is no going back on that. So I don't see that as the path forward. However, my thought, my hope is that if you take a combination of gravity, complementarity, the investigations that not as a legal bar, but as we're talking discretion now. Think about discretion. Should the prosecutor prioritize this investigation or prioritize other more serious investigations? Think about gravity, think about the complementarity, think about all the work that's been done that Jane talked about to correct the practices, and the fact that, and honestly, I think this was an incredibly aberrational moment in U.S. history. I think if you take those things, the prosecutor could say, look, I'm not, yes, the law, I should open an investigation, but I'm not going to prioritize that investigation right now.
And
Just
you could do
quickly.
that within, there are criteria in the policy paper on
Right.
prioritization that would allow for that. I think it's not, there's things you could point to.
Right.
An emphasis on ongoing crimes, whereas here we have self-correction, you know.
So I think that would be a legitimate exercise of discretion, and it would be a strategic one.
And I actually do
Both.
agree with.
Both.
Right.
No, if you're are you finished?
I'm done.
Yeah,
You give the
no, I
last
do,
word on
and
it.
I
Kip
very
gets the
much-
last word?
No.
I have a question for Alex too on, yeah.
Well, I just want to quickly say that I do agree with everything that Alex has said, and so.
Good, that's the last word.
As ways of navigating, but on the rigid, I just wanted to kind of push back slightly on the rigid testing. In different, be it at the International Criminal Court and at other tribunals, the rigid testing is what the United States has pushed on has promoted on other countries. The rigid test has been, you have not gone high enough. And that rigid test has been applied because we say that if you don't go high enough, this is where the kind of the cycle of violence goes. So I think I very much respect and actually agree with much of what Alex has to say. But if we're really gonna be able to apply that rigid test to other states, we have to credibly do it ourselves. So I think that's, one point to make.
But can I just ask a question, because the point that complementarity should be potentially rethought, but with Kip's important point, I'm curious, Alex, you've been at the court, how would that happen? How would that be done? Could there be another policy paper? Who would do it? What would it look like? Is it possible? Is it likely?
Well, there are two ways to do it. One would be through discretion, right? To kind of think.
Have a common law of discretion?
Right. But discretion would be in the space of prioritizing investigations. So you would have this sort of second complementarity test that was in addition to the legal complementarity test that would be about prioritizing and exercising discretion. With respect to the legal complementarity test, it's pretty clearly written in the statute, and it's been interpreted by the court there in this way. So that would be very hard to undo. The only way is by an amendment to the statute, I think.
And the statute is amended by the Assembly of States Parties.
Right, and that would be a
Two-thirds.
very, very hard thing to do
Very
at
hard.
this stage, to open that up.
And I mean, one of the factors in the case prioritization is the cooperation of the state, the possibility of getting a case, you know.
Right.
And then, of course, if you put too much weight on that, you reward obstruction, right? So
Right.
how do you navigate that issue?
Yes, I mean, the discretion in case prioritization has both kind of normative points and strategic points, right?
Yeah.
Practical is a better way to put it. And here I think they're both in the case of the U.S. and Afghanistan. That the court, it's true, it does reward obstruction, but the U.S. is not a state party, so the U.S. has no legal obligation. So in a way, you might say that you're not rewarding obstruction or violation of the statute because the U.S. has no legal obligation. So that's a special category.
All right, it's time for us to get some good questions
Finally.
from the audience. So the floor is open. Raise your hand if you'd like to ask a question.
I'll probably ask.
Okay, we'll start here and we'll move that.
Mr. Hale, you mentioned that it's a mistake for the ICC to pursue the Afghanistan case, but if they don't do that, how will they maintain legitimacy?
Well, I was being.
Wait, did you mean me?
Oh, sorry.
Yeah.
Or,
Clearly.
The other guy with the glasses?
Professor White.
we all look alike.
I need new glasses.
That's right.
It wouldn't be the first time people have said we look alike, and he's a very good-looking guy. He's very good.
Okay. You're 100% right. If the prosecutor doesn't go full bore on the Afghanistan investigation, there will be a legitimacy cost to the court. I agree with you. However, the problem is that there's legitimacy costs on all sides of this problem, and that if the court goes after, tries to pursue the Afghanistan investigation, it will fail. It will fail. It will not succeed in that case, and that I think will also be a legitimacy cost, and it will cause enormous blowback on the court, and I worry that the Bolton speech is real, that the administration will pursue measures, and I'm not confident that the members of the court will fully support it in this day and age. I think we're in a very different environment now from 2002, and the Europeans, they're not going to abandon the court, they're not going to shut it down, but I also don't think that they're going to go to bat for the court at this stage. They have other things they're going to fight for.
Okay, you directed that question to Professor Whiting. And rather than, well, I was going to say, let's have another question or two.
With time, maybe it's good to take a bunch of questions.
Well, all right, we have 10 minutes left, so let's do 2 questions for now, and then we'll panel answer both of them as they wish. I saw your hand up.
Yeah, I have a comment and a question. The major comment is about the very minimal knowledge within the United States on the grassroots and in the public about the court. And the U.S. not being signatory right now to the Rome Statute could take a very visible court proceeding, or in the case of Afghanistan, to highlight some of the problems and bring this more into the public discussion. Because you said there was an outcry when about Bolton's speech. There was no outcry in the public. Among those who are informed and among students of law, yeah, if they were knowledgeable, there was an outcry. But the public, it went by. Totally, it does pass them by. It is, I gave a talk about Rwanda and the genocide 2 days ago at a small university in Baltimore. People didn't even know the definition of genocide, leave alone Rwanda. I'm an Africanist, they didn't know that. I mean, it's just the knowledge is so low that I think one obligation of the ICC in The Hague has to be to inform more NGOs and more of the public about what was the role of the court and what it could be. And I think there was a paragraph about raising awareness, about educating. Where is that going? How is that addressed?
Good.
And that could change the politics in the United States eventually.
Okay, that's one, we'll take that as a question,
Yes,
as a
please.
statement, but we'll put a question mark at the end of it. You agree? Next question, we can couple with that.
In terms of using the jurisdictional hook in Bangladesh over the Rohingya crisis, do you see that globally, not necessarily in the U.S., as something that's legitimizing the court further? Is that a positive step, or is it not necessarily something that's going to result in anything tangible enough to bolster the court?
All right, so let's take those 2 questions, answer either one or both. Let's start at this end. Bill, do you want to weigh in on either one of those?
Not directly, I do want to make a comment about the legitimizing, which is sort of related,
Sure.
in that I'm concerned, just for maybe not directly relevant to the ICC, but for those Americans in the room, there's a presumption that underlies much of this discussion, that there would be a delegitimizing if the ICC didn't go after U.S. offenses. I think there clearly is a perception of it. But Lincoln said that, character is like a tree and reputation, it's shadow. And the point is that the shadow is just a shadow, the tree's the real thing. And there's a lot of misunderstanding about detention practices, and I just want to make clear, I personally, having been a prosecutor most of my career, having been a criminal judge, having been a criminal defense counsel, I don't know of a single case you could bring successfully that hasn't been brought already. You've got Abu Ghraib prosecutions, you've got dozens of military prosecutions for detention practices that have already occurred. You've got hundreds and hundreds, I want to say over 1,000, investigations of potential allegations of misconduct and detention practices. So the idea, and how much are they publicized? That's, I think, a problem and an issue, because not everyone realizes it, but that just goes with the public affairs perception of detention practices. So I don't want anyone here to think that there's a real issue. There is a shadow of the tree issue, because the world doesn't see it that way, and for the court to go a different way would delegitimize it in people's eyes.
So I would just say that if, I think the US government should be willing to be as clear and transparent as I think Bill would be if he were in charge, because I think it's not enough to just say there's no basis. The US would have to be much more transparent about what it has done. It would have to be much more categorical in its opposition to torture. It would have to be much stronger on its commitment to accountability generally. So I think there are things the US could do that would, you know, not completely deflect, but partially address the legitimacy point you make, which I think is a very important one. On public education, I mean, I'm an educator, I'm a teacher, so I very much believe in that in the field of human rights generally. I think it's hugely important. And I think the court does do some of that. The prosecutor is a very eloquent speaker. She does a lot of public speaking. She's done a lot of this in Africa, where she's had to address some critiques and some sort of complaints that she's focused primarily on Africa. So she's worked with civil society groups, with victims groups, and so forth. The budget of the court is limited, but I think this is a really important area. I know that the Unwin case, which is now before the court, is being broadcast in Uganda, and it's stimulating and generating a lot of important discussions about justice. I think it's so important that the court put some resources into that kind of activity. It's not enough just to have the cases in The Hague. They have to reach the people who are directly affected. And then finally on the Rohingya, I think the court has to, you know, focus on something of this gravity. I mean, it's just, you know, it's crimes against humanity, it's genocide. It's of such gravity, and they have a basis because the crime of deportation culminates on the territory of a state party in Bangladesh. And I think the prosecutor did it the right way. She sought a judgment, you know, the pretrial chamber. There was jurisdiction, and I think it's when something is that grave and that horrific, I think the court has a jurisdictional basis. I think it needs to address it.
Okay, Alex and Kip, you want to weigh in on the two questions on the floor?
Well, I would just say on education that I agree. The difficulty that the court has is that it's a little whisper in the world, right? In terms of its voice, in terms of how it can reach people. You know, when I was there, we also had the Kenya case, and the media in Kenya is largely state and politically controlled, and quickly was against the ICC, and people kept saying to the ICC, you have to get your message out. You have to get your message out. I'm like, how? Like, how do you penetrate that? You know, when you have the full media arrayed against you, you know, you can do it on YouTube and on your website and so forth, but that's an enormous challenge. And the court, this is the larger point about the court, that the court is not in control of its own destiny. It is a very weak institution that is dependent on states and other institutions to support it, both in its investigative work, but also in its messaging and in its education. I think the Rohingya case and what the court has done, and what I hope it does, adds to legitimacy, because the perception is those are the sorts of cases that the court should be dealing with.
On the, Kip, I'm going to ask you, on the education part, I started to say that the ABA Icc Project cannot do the kind of widespread education that you're talking about. The court cannot do it, but the two purposes of the ABA Icc Project, one is to educate our own government leaders, many of whom have never read the Rome Statute. Some haven't read the U.S. Constitution. And I can give some examples of that. But the project does convene programs in Washington. The prosecutor has come to at least 3 of those programs in the last couple of years. When something is written, for example, in the Kenya situation, the Kenyan leaders who were under indictment and about to be tried, Kenya hired a PR firm in the UK, and this author wrote a scathing attack on the court, accusing the prosecutor of bribing witnesses to appear, threatening witnesses if they would come, just outrageous things. And the Aba Icc Project responded to that, because that article appeared in The Hill, which is read by all of our government leaders. And so not only a lot of them not educated, then they're being educated by, distortion. So we wrote a response, and it turned out when I read the final version of what was going to be sent to The Hill, which was published in The Hill, the reply, the author was the managing partner of the PR firm that had been hired by the Kenyan government, so he had a conflict of interest that he never mentioned in the article, that would indicate. So agreement on the education. Kip wants to say something, and then we have one last question.
Yeah, just quickly on the education, I completely sympathize with where you're coming from, and to build off what Jane, and particularly about the budget issue, but also, it's a very fine line for a judicial institution to be doing that. I mean, you don't see the Supreme Court in the United States or the Department of Justice, I know it's not exactly apple to apple, but going out and talking to the public about what it's doing. And so, yes, the ICC does have obligations to affect the community, but very much about its objectivity and its mandate. It can't be this kind of full-throated, PR campaign led from the Hague that would really then put it into kind of very much into the political sphere. And so it really does depend on proponents of the court, supporters of the court, like ABA, like other institutions, to pick up that slack. And also, frankly, donors and others to actually put more money in towards that, and towards education of the ICC. I know we're all giving kind of short summary to yours. Yes, it's an excellent way to expand and showing that she and her leadership of the office is pushing the jurisdiction to its full extent. What I would say, a great byproduct, but that's something Jordan can never do, potentially. In Jordan, you have lots of Syrian refugees and others come over the course in Jordan. So now that precedent is there, we can see that this could actually have positive effects in other conflicts.
Well, we're 1 minute past 11. Is it a short question?
Yes.
Okay, short question.
Thanks everyone for being here. Very short, followed by a slightly longer one that I can take offline if that's okay. Technical question to follow up to her question. Will the jurisdictional hook limit the crimes that can be sought only to the crime of deportation or to everything? And if that's the case, it brings me back to something that Bill, I think, mentioned about the UN playing a large role historically. The reason we need this jurisdictional hook is because the Security Council isn't going to refer because there's going to be a veto. Would love anyone's thoughts, and I would love all of them, but probably only time for one person's thoughts, on the concept that has been floated a lot about should the council be including in some way, or the assembly including in some way, a limitation on the veto power in instances of these mass atrocities.
Brought up a lot. No, but that's a hugely important point. The decision actually said, without prosecutors actually urging, actually said persecution and other things could be part of that. Again, where the evidence and law, I would actually argue, I think the persecution is a real maybe too far. But it really is focused on the deportation. Yes, the Myanmar decision, and this was very much because the UN Security Council was abrogating its duty. Whether you're going to have any, I don't think it's even feasible to think that the UN Security Council ever changes rules on veto. I think the only reasonable...
France has proposed it.
France has proposed it with Mexico, but mainly what is honestly the most likely positive outcome is to change the culture of the UN Security Council. As it relates to not using your video in an atrocity crime situation, which is the French initiative. And I'll stop there to hear others.
Quick, the three. All right, will you join me in thanking our panelists?